streaming that onto YouTube. Start recording that onto Collaborate. Hello all, and welcome to what are we? Topic 7. This is the last topic that we'll do in relation to contract law. Now, you may or may not be aware that this semester has been extremely unusual in terms of timing, and that there is in fact another break for a week, so that this next lecture is not going to be for another 2 weeks, which is going to give hopefully all of us, least of all me, a bit of breathing space to go and catch up on a variety of things here. So I think this one's useful because this particular topic, there's fewer slides, there's not as much content, but there is a lot more, I think, sort of real world stuff, because we have to look at some of the statutory instruments, and you'll need them for your assessment as well. So I've tweaked and changed that a little bit. So if you do go back through the screencast for this topic, you will you'll notice some modifications from the screencast to this one here. I've really tried to emphasize the components that are related to your assessment and the components that are a little bit more related to the real world as well. Right, so what is this we're talking about? Well, the previous 4 weeks for this particular component of the subject, which is really the biggest and most important part of it, the previous 4 weeks are about contracts coming together, contracts coming apart. In other words, we're starting with first principles. How does the law of contract work fundamentally? How do you create agreements, bring things together? Once you've brought something together, how do you interpret what you've got? Then the vitiating factors was to look at whether or not there was some form of defect in formation that can be argued separately and distinctly from the issues of formation. And then finally just judge what happens when contractual obligations end. And so this is really the building block, those 4 topics in terms of what contract is as private lawmaking. And so really this particular lecture, this 5th component, is the statutory framework that sits on the top. Because if we think about how contract law developed, remember, this is judge-made law. This is things that have been developed by the court system over a long time. And almost, if you think about how contracts operate, this idea of private lawmaking, the government ideally doesn't get involved, doesn't interfere with these things. And so as such, it got developed by the courts over hundreds and hundreds, 500 years, to try and really map out how the most fair system of private deal making worked. This idea of private law, it's really, really important, and why that it developed quite considerably and strongly in the common law jurisdictions. However, sometimes the courts have their hands tied, and sometimes Parliament needs to intervene. Parliament needs to stop to regulate and to encourage certain types of behaviour in the economy as a whole. And so that's really what this component is. It's the statutory framework that sits over the top of the common law rules to provide some form of guidance. Now, you will also recall that whenever you've got a common law rule, like judge-made law, and you've got parliament-made law, this one will trump this one. There's no mechanism for the courts to override the clearly expressed will of Parliament. And so that these laws that we have, that we're going to go through today, is laws that have been created by parliaments over most of them over the last 40 or 50 years. There's one which is a little bit older than that. There's a particular reason for that too. And the reason why Parliament hasn't really intervened with this stuff very much, it's that idea that people are free to do as they want. The whole purpose of contract law and private deal making is that parties come together to do their own thing. We're only concerned when things go wrong. And so the courts were really concerned about the fairness of this process, to obtain this true meeting of minds and trying to really limit the overall transaction cost of doing things. And because fundamentally that's what that's about. It's about this idea of individuals taking control of their own lives. Who's in the chat at the moment? Elma. If Elma has a boat, I have $10,000. I want a boat, he wants $10,000, we swap. That doesn't involve any form of government department. That doesn't involve any third parties. And if that transaction, the process itself, is fair, then those obligations cease and we don't have to worry or think about it anymore as part of that process. And that's why this idea of the caveat emptor concept, really what that is, which is basically let the buyer beware. Just be careful, be diligent. Don't expect others to bail you out or to get you out of trouble when you make bad decisions and you make bad contracts and bad private arrangements. Look, and that does work to some extent. And again, the courts were pretty good at mapping these things out to develop this idea of fairness and to really mold this area of law over hundreds of years. What you found, though, is that there are a bunch of rules by the mid to late 1800s. There were a bunch of rules that were stored in cases all over the show. And so what the British decided to do, which was picked up by the various colonies, was to actually take those common law rules and just put them into a simple, very short statute. We call that the Cellar Codes Act. So if you look at the year on the Cellar Codes Act, I think it's 1896. So it's 124 years old, plus or minus. It's old. But the key thing to note about the Cellar Codes Act is that it was designed to just take all of the rules that existed in the common law at that time and just map them out in one place. The simple rules that people could just go through and read. And when we get to the Cellar Codes Act, which is one of the acts we're talking about today, a lot of those things can be modified by agreement between the parties. And this is different and distinct from more recent legislation, such as the Competition and Consumer Act. Competition and Consumer Act is a 2010 piece of legislation that came into force on the 1st of January 2011. And it actually flowed from an earlier piece of legislation from the 70s, the Trade Practices Act. And so often you'll see references to the Trade Practices Act and sections in that act. What they actually did, curiously, is they didn't actually repeal the Trade Practices Act. They just passed an amending act which changed the name. So they just literally changed the name of that piece of legislation and added a schedule to it. And the Schedule 2 of the Australian of the Competition and Consumer Act, CCA, is called the Australian Consumer Law. So you'll see those three terms are used throughout this particular session to describe those three pieces of legislation. SOGA, Cellar Codes Act, the CCA, which is the Competition and Consumer Act, and the Australian Consumer Law, the ACL, which is Schedule 2 inside the Competition Consumer Act. Okay, so doesn't actually sit as a separate law unto itself. Okay, another thing just to note too, and again we've talked about this in week 2, which is this idea of dispute resolution. One of the key aspects when we think about contractual regulation is actually to try and get parties to solve the disputes without resorting to litigation, without the government departments needing to regulate it, because regulation's expensive. Okay, right, but here's some examples though. Now, I'm only talking about, for this purpose of this session, we're going to go through in depth the three laws at the top. However, there are many pieces of legislation which modify contracts in some way. And so, in fact, a very early one was something called the Statute of Frauds from the reign of, I think, Henry VIII. So we're talking 1500s. And that was the statute which said all contracts for land must be in writing. And these days, this is enshrined in Section 11 of the Property Law Act. It's a Queensland piece of legislation. But there's other types of contracts that are regulated. So contracts for land, you said, they have some rules in the Property Law Act. Contracts of employment have rules, extra rules that sit on top of the ordinary rules of contract for contracts of employment and service. Insurance Contract Act for insurance, the RTRAA, Residential Tenancy and Rooming Accommodation Act for residential arrangements between people. The banks or contracts with banks are governed by the Banking Act. Buying and selling a car is the TORAM, the Transport Operations Road Use Management Act, TORAM. Other things have pharmacies and the selling of drugs and poisons is governed by the Health Act. The Weapons Act for the buying and selling of weapons, and so on and so on. There are many, many, many situations. Tala, question.
Hold on. Why do you need a Weapons Act if weapons are not allowed in Australia?
You're allowed to buy and sell weapons. Sometimes it's just regulated. So the idea is that the Weapons Act, from what I believe when I read it, is just says thou shalt not buy and sell weapons without either being a licensed weapon dealer or without obtaining the appropriate permit or regulations and effecting the appropriate transfers, i.e., ensuring the appropriate amounts of ID are shown and the registration for those things passes between the people. It's really not about, some of these things are not about prohibiting as such, it's really about regulating. The purchase and sale of uranium, for example. You probably could go through and buy and sell uranium, but it would be very heavily curtailed by the relevant federal statutes that go with that. I sold a car just recently, and if you read the TORAM, it says that when you sell a car, you have to sell it with a roadworthy certificate. And I didn't have a roadworthy certificate, so I took the plates off it and sold it. And the thing is with that, interestingly, is that you actually can still sell the vehicle under the general law. In other words, through the common law. You are still able to do that. It's still each of the individual components in that car I could sell, but I can't sell it with the registration plates on it. That's forbidden. I have to take the plates off, and you can sell a vehicle as is, as such, without being governed by that particular statute. So really, it's designed to regulate the transfer, not to prohibit it in entirety. Good question, though. Okay, so just note for these other bits of legislation, I don't go into them in depth for this particular topic, and I don't assess them as part of that. But maybe we'll one day. I think I might talk about banking. No, actually, I don't think I do these days. I used to talk about it in the subject. So you may find in the screencast that I talk about the Banking Act, but none of the others, other than maybe the PLA, the Property Law Act at some stage. All right, so we'll make a start on that. The first one we're going to look at is the Cellar Codes Act. Cellar Codes is, again, it was this a piece of legislation that really just was designed to consolidate, not even codify, but to consolidate the common law of the late 1800s into a bunch of rules. And these rules impact what we would say are the default rules for selling goods. And these rules really, though, they actually flowed from something, and Rico may be able to enlighten me a little on this, the Lex Mercantia, the law of merchants. So a lot of this stuff, when we look at the common law rules of England, we appreciate that in Europe, you had a variety of what we would now call transnational entities. You had the religious groups, you had the various churches, and Christian churches, and after Martin Luther, the Catholic Protestant divide. Still the Orthodox ones, which had split a long time before that. You also had the merchants, and so the merchants, as part and parcel of operating in society, would have their own rules, their rules that they used with each other. It was called the Lex Mercantia, and those rules got absorbed into the common law of England. You probably would have heard of that. And that's why these rules, even though they've had frameworks for creating and enshrining and codifying these things after the end of the Second World War. A lot of it owes its existence to the laws of merchants. Because if you think about it, the people that are buying and selling stuff, who are both good at buying and selling stuff, when they have disputes, they're usually going to be some sort of technical reason. Each of them, they're not going to have difficulty knowing or understanding the underlying fairness of it when you've got essentially powerful players who are experienced at selling stuff. And so what you find is that the rules of merchants were mapped out over thousands of years, where they would come up with their own rules and they would have their own systems of arbitration that would sit outside national national court systems, because the stuff predates nations as a concept. If you sort of think about that, and again, the history of the city-states, particularly in the Italian peninsula, Genoa, Naples, Venice, and so on like that. The various sort of merchants that they would have, and the rules they have, is that's where a lot of the stuff flows from. Okay, so a couple of things to note about the Sale of Goods Act, and really importantly, almost all of the rules in the Sale of Goods Act can be changed by clear express agreement between the parties. I'll say that again. Almost everything in the Cellar Codes Act can be changed or modified by the parties to the contract. If the two parties want to change certain rules about, for example, the guarantees as to title or to quality or other components of it, they can do that. They just map it out in the contractual instrument, or possibly even just do it orally, and that's fine. And when we get to the Australian consumer law, you'll notice that that's the single biggest difference between the guarantees that you have in the Australian consumer law as opposed to the Cellar Codes Act. Everything here can be trumped, can be changed. So what we're looking at here are the standard rules that happen where we don't talk about it. So if you don't agree to change any of those rules, which can sometimes happen if you don't know their existence, again, this may be new to you guys. If you don't change those things, then the way the Sale of Goods Act works is that these rules will apply. Okay, and so that's basically how where this sits. So odds are good if you're buying something over the internet and it has one of those long standard form contracts where you have to scroll all the way to the bottom and click accept. Odds are good that they've gone and modified a whole bunch of these things as part and parcel of it. And if that's the case, you have to go and use that instrument. These are the rules that happen if you if you haven't, if you're buying and selling goods and you haven't gone and expressly changed these things. Also note that unlike the Australian consumer law, some things, unfortunately, in the Sale of Goods Act, actually slightly different between jurisdictions. Some of the states, for whatever reason, have changed little bits here and there over time. There's nothing too major. I'm not going to address anything like that, but just be a little bit mindful when going through and making particularly large sales for goods in the common law. In other words, where the Australian consumer law doesn't apply, to really go through and map these things out. Change the things that you don't like. Okay. Now, an important concept when we're looking at the law of selling goods, but the Sale of Goods Act in particular, is the idea of title. Title is ownership. Okay, now we think, title, title passes. If we think about it, when you go to the supermarket, title in the goods passes when you pay for it. Well, this is true when you're buying something from the supermarket, or when some guy comes down here to buy my car. That is true. Title does pass for most things that we do because we don't have those systems of trust. But we appreciate that for most business transaction, and certainly you guys doing finance are aware of this, you usually purchase goods on terms. 30, 60, 90 day, whatever the particular terms you have. It's a curious rule because it allows people and businesses to purchase from their suppliers and obtain essentially a line of credit for a period of time, and you have to pay at a later stage. So it's really important to know when the goods become yours, because that, in terms of when you are then going to argue over the goods, particularly when things go bad, you've got to work out who actually owns them. All right, so and so there's a couple of things to note. Well, I've got half dozen here that are actually really important features of title passing. Again, which you map out in the contract, but you can you can go through and map out to change it. Otherwise, you'll use the rules, which are on the next few slides. And the first thing to note is that when you're purchasing something, whoever has title, unless it's been trumped by the agreement, has the risk of those goods. So once title is passed, the person who has title bears the risk of them being damaged or destroyed or stolen. Okay, and that's an important consideration, because remember, if a contract is formed and you specify when in that contract a particular the particular series of goods actually transfers from one to the other, risk by default will transfer at that point in time. And again, the auditors and accountants and financial guys, putting your accountant hats on, you can see why that's important. The right to sue for the price. The price is the amount the goods were sold for, or can refer to a mechanism of calculating a particular price. But basically, the right to sue, you gain that when title passes to you by default. By default, if no prior agreement has changed that. I'm going to be repeating myself a little bit on that term, because all of these things can be changed by agreement, all of them. By default, you get when title passes to you, risk passes to you, the right to sue for the price. In other words, to ask for to be a right to sue for the person who sold those goods arises. You also, I've actually kind of mixed this up a little bit here. Number 2 is referring the right for the seller to sue. Number 3 is to do with the once the person who has title, so once the buyer has title, if somebody else comes and takes them away, you get the right to sue them in conversion if they do something repugnant to your right to possession. So that's the packet of rights that you get at that time.
Give an example to that, please.
Yeah, sure thing, Tyler. If I was to sell you 500 bags of ground nuts, I use particular examples from cases, and we didn't agree at the time that we'll say we did agree that title will pass when I deliver them to the wharf. Okay, so if I deliver them to the wharf and you haven't come to pick them up yet, but in our contract it says title passes when they're delivered on the wharf, they are yours from that point. And so by default, I get the right to sue you for the money that is owed to me under the contract. That's item 2. Item 1, risk is going to pass to you. So if some squirrels come along and eat some of the ground nuts, all right, so they go and eat 10 bags of ground nuts, you have to bear that cost because title is passed to you. If the wharfies, so the wharf people, some people there come along thinking that it's their ground nuts and stop you from taking them, you get the right, because you have title, to sue them in what's called conversion. They're doing something repugnant to your possession, your right to possession. You have the right to sue them if they don't give you your bags of ground nuts back. Okay, that's that one. That's what each of those things, you get those powers once you own something.
That's the example for the third one, right?
Mm.
The wolf one that you given now.
Yeah. So that's right. Right. So if I've delivered the ground nuts and our contract says title passes to Tala when they are delivered to the wharf, once they're on the wharf, that's it. They're not mine anymore. They're hers. She bears the risk of any damage or loss. She gets I get the right to sue her for the price, the amount of money that it's been sold for. She gets the right if somebody comes along and does something. And we'll talk about tort. Conversion is a tort, which we do in 2 weeks' time because we're going to break. If somebody does something repugnant to your rights or Tala's rights of immediate possession, she can sue them. She can also sell them. And when she does sell them, those people get good title to those goods. There's a rule. Yeah, there's a rule I talk about a little later in this particular lecture as to what that exactly means. Basically, it means that if you think about it, if you steal something, all right, and then you sell it to somebody else, does the person you sell it to own it?
No.
No. The person who it was stolen from still owns it. Okay? And in common law, we don't care in terms of this. All right. So let's just say a different example. All right. I have, okay. Enrico has a TV. I come into his house and I steal it and I sell it to Hina. Okay? Enrico has a television. I'm the thief. I come in, get the TV, I steal it, and I sell it to Hina. All right? And then one day, Enrico is over at Hina's house and says, Oi, that's my TV. And Hina says, Oh, no, I bought it from that tall, bald guy for $50. Who owns the TV? Yes. Yes, that's right. That's right. At common law,
Has never been transferred.
yeah, well, it's really that me as the rogue, I can't give better title when I unsell it than what I have. So if you think of it as a chain of people, each given step you cannot give better title than what you currently have. So I can't cure this defect. Me as the rogue, I can't make this lawfully mine to be able to sell it to Hina for her to get good title. All right. So as in that particular example, title ownership still resides in Enrico. And again, there's some exceptions to that, but we get to those in about 20 minutes.
And who's the person that sold her the TV?
If she can find him, but he's really good at running. Usually, in these examples, the rogue is either disappeared, so you can't find them again, or they've got no money. Because usually, what happens in law, when I got taught business law 25 years ago, the first thing they told us was deep pockets theory. You only ever sue people who have money. There's no point doing it any other way. And so the fact that if Hina and Enrico are arguing about this, Enrico's right. Hina can go back to me in this case and demand her $50 back. She still has that right to go through and do that, but he owns the TV. So he can literally pick the TV up, take it home.
Yeah, but I need a paper from the judge because otherwise.
No, oddly not. No, it's a self-help remedy actually. If you can prove it, again, don't get me wrong, you're going to have to be able to prove it, but it's actually a self-help remedy. Some things, and again, I try not to really overemphasize these things, but basically, it's yours. It was always yours. It never ceased being yours. I've actually.
There is a difference between property and possession.
Oh yes, yes. So at that moment, Hina has possession, but you have ownership. You have the higher form of title. I mean, we'll talk about property in 3 weeks' time, in terms of that little hierarchy of those things. But I think it's a good example though, because it is a self-help remedy. You can literally, if I've seen this happen. I literally, a guy I worked with, one of his friends, went for a test drive of a car, and when he went for this test drive, because his car had been stolen, and he found there was a car that was exactly the same as his, and so he went and looked at it, and then he's test driving the car. It was his car. It had the same mark. It was a big guy, and it had the same hole, slight dip in the arm where his arm would go, because he had a big arm on it. It had the same scratches in certain places on it. It was his car. So some guys had just stolen it and changed the registration plates. And so yeah, that is one of those moments where, again, you better be right, because you can imagine that people get really upset about that. Hina's not going to be very happy about that. But strictly speaking, it was your television. Okay, again, there are some exceptions to that. We'll get to those in a minute. Okay, another reason that, yeah, Nathan, is it? Yep. I didn't catch that. Sorry. Just try again. Yes, yeah, you could argue unilateral mistake, but in either which way it doesn't matter because it's in terms of trying to undo the contract. Because Hina, yeah, there is unilateral mistake. She is mistaken about the she she is mistaken in regards to me, the rogue. So yeah, she could bring an action against me, but I'm gone, so it doesn't really matter about the action against me. She could call the police. She could do whatever her like. In this situation, it doesn't matter in terms of what the rogue has done in selling the television to Hina. He's not there. I'm not there. And so you're trying to work out in any given moment does Enrico in this case get the remedy, so that yes, it is unilateral. It's also misleading. Um, it's also misrepresentation, I imagine. Um, but in that situation, it really doesn't matter. Okay, another thing to note about title to goods, about ownership, is that when certain things happen in your life as a natural person, um, and your death, I suppose, one of the things that if you become bankrupt, or you're a company and you end up going into liquidation, or you're a natural person and you die. In those three situations, the title, if title is vested in you, and then you go bankrupt, go into liquidation if you're a company, or die if you're a natural person, legal title goes to another person. It either goes to the trustee in bankruptcy, or the liquidators, or the executor of an estate. So each of those three people. So if title has passed, and then that event happens, that title will pass to one of those three peoples, depending on which situation it is. So that's important to know, because if you are the liquidator or the trustee in bankruptcy or the executor of an estate, it's important to know whether or not title has actually passed. That's why we need to know these things, because when we think about goods, it's not just sort of small things like this can of Pepsi Max. It can be very, very expensive things. You could buy you know, a, a jet, or very, very large and expensive things. Personality can rack up. Okay, the last one is an interesting one, though. It's important because we've just gone through and talked about last week about this difference between contractual conditions and contractual warranties. Now, do you guys remember the difference between a type of term that's classified as either a condition as opposed to being classified as a warranty? Do you guys remember that difference? There's one really important difference between those things. Does anybody remember what that was from last week? Anybody want to hazard an explanation? Yeah, perfect. Thanks, Katana. Yeah,
It's the essential part of the contract.
yeah, it is. Well, Katano's he's hit the nail on the head there. If there's a breach of condition, you can terminate the contract and seek damages. In other words, end it right now. However, in sale of goods law, by default, once title has passed, all breaches of condition are treated like a breach of warranty. So what that means, translated out of legal speak, is that once the goods have gone from one person to another, once title is moved, you can't terminate the contract. You can't get your money back once title has passed by default. Again, you can map out however you want if you want to change the contract, but at common law, using the Sale of Goods Act, once title is passed from seller to the buyer, doesn't matter at all how and where payment works, breaches of condition are treated like a breach of warranty. In other words, you can't terminate. You can only sue for damages. And the really important thing about that, this idea of terminating, is that you can't refuse the goods. Or, I mean, you can refuse the goods, but they're your goods. Once that has happened, you cannot terminate the contract. It's a pretty important rule. So and again, when we talk about some of the other rules, be really careful when you accept goods from another side, because once you've accepted them, you've inspected them or had the opportunity to inspect them, again, without any other rules in place, once you've inspected goods, they're going to become yours. And that Section 14, subsection 3 is going to apply. Breaches of condition are treated like breaches of warranty. No takesy-backsies. Okay, so again, we've got, these are all rules that can be changed. We can change when title passes. The next two slides, though, are the default rules. These are the rules that, assuming we don't talk about it, we don't agree it, these are what the courts say the defaults are. So I like to think of them as default values. When you go into a form, when you're on the internet filling in a form and it's got default values, that's really what these rules are all about. That's what the Cellar Codes Act is really all about. It's assuming we haven't changed any of these things. What's the standard form of agreement? Okay, so you'll notice that first line in section 20, it pretty much maps out what I've been saying. Title of goods passes from seller to buyer when the parties intended to pass. Okay, it's only when either the instrument, the contract is ambiguous or uncertain, and the parties don't really agree on it. When it's ambiguous, these rules are going to apply. Okay, now one of the kind of annoying things about this is that this is 120 odd years old, so it's a little tricky to read. The rules are a little bit wordy, and a lot of the words have particular technical meaning that comes from the common law anyway. So while it's quite nice in that it's short, the Cellar Codes Act is very, very short. Unfortunately, to actually really interpret in depth, you've probably got to spend, I don't know, I think we do 6 weeks or something on it when we study commercial law for this degree, or for the law degree anyway. Okay, so if the parties are it's ambiguous or you can't tell, they didn't really agree on it, by default, when there is a sale of what we call specific goods, in other words, goods that can be ascertained, that are deliverable, in other words, they have been brought into a state to be delivered from seller to buyer, property, in other words, title, is going to pass when the contract is made. So an unconditional contract sale of specific goods, in other words, goods that can be ascertained, you can point to the shelf and say, this item, the example I gave 2 years ago, maybe last year, a couple of years ago, was actually to do with me buying some stationery. It was a really annoying thing. I went to QCAT and everything. When buying stationery, if you think about it, if I'm buying from a stationery supplier, they were in New South Wales, but leave that aside. When I'm buying stuff, then when the contract is formed, in other words, when I filled in my thing on the internet and paid the money, are those specific goods? In other words, could they be identified at that moment? What do you guys think?
Yes, they can.
Yes, they can. So do you think at the exact moment that I bought that and I clicked on buy with this stationery, which has an entire warehouse of all of this different stationery, they can point to each item and say, that one is Simon's, this one is Simon's, this one is Simon's, and that one is Simon's. If I've selected them, yeah, although is that usually how something like Amazon works? Do I get a drone and get to go through and point? Because usually it's not. Usually, yeah, you're picking a particular class or type of item down to a particular thing, can have a particular product code, like a barcode. Where's a barcode? There's something with a barcode on it. Here's a book. There's barcode. All right. This barcode is unique for this class of product, but it's not unique to this particular item. If you go to somewhere like Harvey Norman, they will print a barcode which is unique to just this particular item. So it'll still have that one, but it'll have every individual copy of this book will have a different serial number on it. So if you think of it like that, it's the idea of these specific goods are really goods with a specific code or a very specific allocation for one thing. If it's something where they're just going to get some items from the bulk, pick one, and then what they call appropriate it to the contract, that's a different thing. That's rule 4, I think. 4? No, it's rule 5. Okay, so that's what that one is. So that by default, if there is a specific good, so I'm buying, I can't remember who it was. I think it was Elmer's boat for $10,000. There's one boat. So it's an unconditional contract. In other words, we've got nothing else in this agreement that says this transfer is subject to some sort of condition. All right, it's in deliverable state, assuming that boat is ready to go. It's not on dry docks. When we have the contract, title passes when the contract's made. Hey, Elmer, can I buy your boat? You go, yes, it's $10,000. Well, $10,000. Okay, I agree. Contract's formed. I'll come back and pay you tomorrow. Strictly speaking, title passes at that point in time. Here you go. Have a think about that. Title passes. And it is immaterial whether the time of payment or the time of delivery or both is postponed. Okay? First thing you need to know. There you go. There's first rule that we've learned. Because the Cellar Codes Act, yeah, tell her.
So technically, if I said, so we agreed that I bought the boat.
Yep.
The boat is mine, and I didn't pay. I said I'll pay you in the next couple of days. Can
Yep.
I drive and take the boat and take it home?
Yes. Yeah, again, unless the agreement says otherwise, it's your boat. It's your boat. You agreed it. You sold it. That's right. Now,
If it crashes and burns as it sits,
sorry? Yes.
insurance needs to cover it.
Yes. So if that boat burns down, yeah,
Oh,
that's right. And so those things. And look, don't get me wrong. When that happens, you'll have the other side saying, "Oh, no, no, no. What we actually intended was this, 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 and this. Oh, that would be crazy to think that that thing had transferred." And so that you will have parties trying to argue things. And this is why you don't want to have oral contracts, by the way, because then it's going to turn into a he said, she said type situation. But assuming that we don't talk about the time of title transferring, that is the default rule. It's just that it just is. That's just the law of the land. So yeah, it's interesting that the title passes at time of formation if the goods are in deliverable state and they're specific goods. In other words, they can be identified. Okay. Now, but if the seller has to do something to put them into deliverable state, in other words, had to give it a clean, for example. Oh yeah, I'll give the thing a clean, or I'll give it a coat of paint, or I'll wrap it up. Don't know how you wrap up a boat, but wrap up the stationery, for example. Then Rule 2 is going to apply. Still specific goods, they can still be identified. But if the seller is going to do something as part of this process, then that particular title won't pass until that such thing is done and the buyer has notice that that thing's been done. Okay. All right. Rule 3 doesn't. Oh, it can come up if there's goods in a deliverable state, but the seller has to weigh, measure, test, or do some other act for the purpose of ascertaining the price. So, say for example, we'd had this boat, and I'd agreed that I would pay. I'm trying to think of a. I don't know whether boat's a particularly good example. Maybe I'm paying for here's an example. Nathan, you've got let's say you're an avocado farmer, and I'm going to buy your whole crop. Okay, I'm going to buy all of your crop of avocados. Okay, and you've gone and you've taken the avocados, all right, and you put them all in boxes. Okay, because this is this distinction here. Putting them in boxes means that they become specific goods in a deliverable state. Okay, but you don't know how much there are or how much we're doing it. So if we've agreed, for example, that I'm going to be paying, I don't know, $10 a kilo for your avocados, you're going to have to weigh them before we can ascertain the price. And so there they say, look, property doesn't pass until that particular thing. In that case, the weighing or measuring of how much there are is done. And again, the buyer has been given notice of that amount. Okay, that's how that works. Rule 4. Okay, when Rule 4 is what's called an on sale or return. So that usually happens when you've got some sort of right. You've said you can go and take the particular goods, and you get the option to send them back. So if, in other words, we've agreed, but as part of, which is the sort of thing merchants do, hey, yeah, I'll take these things and then I'll try and sell them. But if I don't sell them, I'll give them back to you. That's where Rule 4 came. So again, it doesn't really see that much play usually because these sorts of things get mapped out in the agreement. You will take these goods and you will have them for this length of time rather than just a reasonable time, which is what the default is. Yeah, Tyler?
Is it what's called consignment?
Yeah, sell on consignment, or on commission. No, yeah, I think they might use that term. I don't know. I'd have to go and check. I'd have to Google it. I'll Google it during the break. Um, Possibly. I haven't heard that particular phrase. Sell on consignment. So that idea that you can have them and then you can on-sell them, but if you can't on-sell them, you can send them back again within a reasonable length of time. I think that maybe it is. I'm not sure. I'll check during the break. I genuinely don't know. Hina.
Sam, selling back is the condition that it goes by my virtual shop. I give them if you sell it, that's you good, but if you can't sell it, I take it back.
Yeah, something like that. That's right. Essentially, that's what it is. But you can't. Title is still going to pass after a length of time. So, in other words, if you don't agree, and this is usually these things you want to map these things out. But if you don't, particularly where you've got merchants and things like that doing things over a long time, then title is going to pass after a reasonable time. All right. Now, Rule 5 is the one that my students had to look at last year or the year before for that assignment, where there is a contract for the sale of unascertained or future goods by description. All right, unascertained is where you're not selling specific goods. They're either goods that are in a bulk that haven't been unconditionally appropriated to the contract, or they're future goods. They're goods that haven't been made yet, haven't ascertained or even manufactured those. And you can only pass title, by default, title will pass when they are unconditionally appropriated to the contract. So in the case of the stationery company, they've gone into their warehouse, they've pulled out this bit, this bit, this bit, and this bit, they've put it in a box, and they've put it with the courier. Okay, that particular point in time, that is when the contracts are unconditionally appropriated. In other words, they can't be put back into the bulk. That's how Rule 5 works. That is the default rule for the transfer of title for unascertained or future goods. So goods where at the time the contract was formed, these goods either didn't exist or they were in a bulk and they had to go and be picked out of that bulk and what they call unconditionally appropriated to the contract, put beyond recall, usually by giving them to the courier company, and the courier company goes to take them away. That's the point in time where title is going to pass. Okay, and that's Rule 5. And that's the end of these rules, by the way, the transfer of title rules. So there's a little bit to think about there. Trying to work out whether we should take a break. No, we'll keep going for a little bit. We'll try and just do this in one go, I think, to do with the transfer title. Now, before the example about the TV is actually a good one, because this is what's known as the Nemo dat rule. It's a long, complex Latin phrase. I only remember the first bit, which is Nemo dat. And really, it's just restating what seems like common sense to us, but they expressed it in quite sort of clear legal language here. When you sell something, the person and somebody buys it, they can't get better title to those goods than what the person selling it had. So you can't sell something and cure any defects of title that you had. For example, I might have had some form of conditional title that says that a thing called the Ramalpa clause. Ramalpa clause is a clause in a contract it's from a case called Ramalpa Aluminium from 1976 that says title will not pass until the goods are paid for. It's a pretty common thing when you're having goods. So basically, it's retaining title until goods are paid for. So that if you have goods, but we'll go back to the example of the 500 bags of groundnuts left on the docks for Tala. If instead our contract had said title doesn't pass until they're paid for, all right, and somebody comes up, or so Tyler comes up and then on sells that to George, then that title, Tyler can't give better title to George than what she already had. And she didn't have title because she didn't pay for it under that contractual instrument. So, and this kind of makes sense. If somebody steals your TV and then sells it to somebody else, the person who is receiving those goods doesn't own them. It simply doesn't own them, and it's always been part of our legal system. But like a lot of rules, there are exceptions to this, which I'll bring up on the screen in a second. Okay, all right. So I'm not going to go into these in a great deal of depth, but really, if you think about it, using a little bit of scenarios of where the Nemo DAT rule wouldn't really or isn't appropriate to apply. When you go into a store, usually you assume the store owns all of the goods that are in there, right? That's usually how these things work. And so there are some situations where there are, as an exception to Nemo DAT, estoppel, in other words, where there's been some sort of detrimental reliance by one party in equity. Agency, where a person's selling something on behalf of somebody else. Court orders. A mercantile agent is a person who commonly deals with those sorts of goods. So in other words, when you go into a car yard and you buy a car dealers normally deal with cars. So therefore, when you buy a car, again, this is under the old sort of common law rules. These days, it's all heavily regulated. A better example might be a gaming store. You go into a gaming store and they may sell collectible cards, for example. And the person in the card store owns a card store. When you go in there and you buy something, it is an exception to Nemo DAT. In other words, the person who's selling it is guaranteeing title in some way, and that'll actually cure the defect between those things. Don't get me wrong, if they were, Tyler, if these were your cards and this dealer had obtained them from a rogue, you may still have an action against the rogue or the shop dealer for doing that, but you don't have a remedy against the person who has the cards in the end in that case. It cures the defect. Avoidable title, that goes back to the things like that Ramalpa clause I talked about before, where they had the option of voiding it as part of the instrument. If you leave stuff with the seller for too long, or if you leave stuff with the buyer for too long, that will actually be an exception to Nemo DAT. In other words, if they're just holding on to the goods until the contract is finished for a long period of time. And the last one actually only applies in a couple of states, in a market overt. The idea being that it's a pretty silly old rule. Actually, if you think about it, with a conventional market, when you're walking around the market, in theory, the person, Enrico in this case with the television, can just go to the market and see all of the goods that are for sale in that market and purchase it. Again, it's an old rule. I presume that the Western Australian and South Australian guys just haven't taken it out of their legislation. Don't know why it's even still there. All right, you don't really need to know those things there, other than the mercantile agent. So that idea, when you go and buy something from a person who deals with goods of that type, that will actually be an exception to Nemo DAT. All right, person who deals with those goods regularly, you will get good title by default when you're purchasing those things. If they've been buying stolen cars or stolen collectible cards or what have you, there may be some remedy for a person who discovers this later on. You may be able to seek remedy against that person, but the person who purchased the goods from that dealer doesn't have to give their things up. So in other words, if this television that Hina had bought, even if it was stolen from Enrico and ends up in the second-hand second-hand television store, Hina comes in and buys it, she will get good title in that situation. That will actually cure that defect. Enrico may still have an action against the particular vendor or seller of that particular television, but he won't have one against Hina. It's an exception to Nemo DAT. Okay, that's the main one. All right, implied terms. Now, these are interesting. By default, when you purchase goods, these particular terms are incorporated into the contract. They are what's called implied terms. And remember, we talked about implied terms 3 or 4 weeks ago when we talked about terms generally. Courts don't imply terms lightly for custom and so on like that, and in the common law. But the Parliament made law, statute and legislation, that will always trump the common law rules. And so as such, these are the default terms that apply for all sale of good contracts unless you've trumped them by agreement. You can always just go through and say all of the implied terms in the Cellar Codes Act do not apply. You can easily put that in your contract. If you don't, then it's an implied condition that you as the seller have title. So in other words, you are guaranteeing that you have title to the goods when you sell them. And it's a condition. If you do not have title, if it turns out you don't have title, because you've guaranteed the truthfulness of this, it's implied, the other side, the purchaser, can terminate and seek damages. Okay, if you have a contract where you're selling by sample, say you're selling carpet, for example, and you've got a little bit of carpet, there's an implied, again, a condition that the description or sample actually matches the goods that are being sold, if that made sense. So that I'm showing you the sample, it has to actually match the goods themselves. Okay, it's also an implied condition of sale of goods that goods are fit for each disclosed purpose. Okay, this is important because a lot of these things, by the way, have equivalent sections in the guarantees in the Australian consumer law. Some of them, though, are different. Section 17A and 17C are different between those two acts. The Sale of Goods Act, remember, this flowed from the law of merchants. It has a much lower bar in terms of what it imposes on the seller. So the seller only has this implied conditions that the goods are fit for every purpose disclosed by the purchaser to the seller. All right, so if, for example, I have sold these groundnuts to Tala by default, and we're using these default rules, but she mentioned to me that she was going to go and feed her prize, I'm trying to think what they were called, prize foxes. I think there was a case. I think that's what it was. Yes. And I said, yes, these will make an appropriate food for, sorry, in fact, no, I don't have to say anything. So she just says to me, she discloses to me as part of this, part of the negotiations, that she is going to use these groundnuts for feeding her prize silver foxes. Foxes, maybe minks. I don't know. There was some animal with a fancy coat anyway. And if it turns out that these groundnuts were fit only to feed pigs, all right, and it kills the her silver foxes, then I'm going to be in breach in that situation if she disclosed that to me. If she didn't disclose it, then all I have to have is what's called the goods to be merchantable quality. And I actually like the word merchantable because it's the sort of quality that you expect from merchants selling to other merchants. It is not a guarantee that they are safe. It is not a guarantee that they're fit for all purposes. It is not a guarantee that they reach a certain level of high quality, because merchants, when they come together, should be able to identify the quality of goods. You as a merchant are always allowed to buy low quality goods and pay less money. Okay, that's part and parcel of it. That's why these rules, Cellar Goods Act, is really about merchants coming together. And you'll see when we talk about the ACL later on, those rules that are written in very similar ways, very, very similar style, but they set a much higher bar, because when you and I go into the supermarket, or we're going and buying feed for things, if we're the consumer, we're pretty dumb. We just basically assume consumers are dumb, and we assume merchants are smart. Implied conditions how the sample by the bulk shall correspond with the sample. And again, if I had given Tala a sample of a small bag of groundnuts, and then she's gone and bought 500 of those, this small one should correspond to the bulk, the 500 bags that I've sold her. Implied condition sale of goods contract bought by sample. The goods are free from defects that are not apparent on reasonable examination of the sample. And these are defects, a very specific meaning, free from defects that would render them unmerchantable. And again, going back to this idea of merchants coming together, if when I demonstrate the sample, all right, if she couldn't tell that these ground nuts were actually rotten, they were like 3 months old, all right, she's given them examination. Again, it's an objective test, a reasonable examination of the sample. Then, it's an implied condition. And if I'm in breach of that implied condition, if the sample that I've supplied to her, if she couldn't tell that this feed was all off, that these ground nuts were all off, it wasn't apparent to her on a reasonable examination of those of that particular sample. That's really how those works, guys. I know this is a little bit heavy to go through as part and parcel, but think like a merchant. Put your merchant hat on. You're thinking like a person who buys and sells things regularly. All right, that's really the key thing, the key theme of the Sale of Goods Act. It's to do with mapping and managing rules for merchants when people are buying and selling stuff, but it is still the common law. It is still, these rules will still apply to all sale of goods if you don't expressly agree otherwise. These things are implied into all contracts for the sale of goods. So leave that one in the back of your mind when you go through and doing it. Okay, it's 7 o'clock and I'm just about to change topics. So what we're going to do, we'll take 5 minutes. I'll go get a drink and then I'll come back, if that's all right. All right. Give you 5 minutes. Thanks, guys. Oops, apologies for those that were on the YouTube as well. I'll just repeat a little bit of what I've said here. The Schedule 2 of the Schedule 2 of the Competition and Consumer Act is the Australian Consumer Law, and it applies as a law of the state of Queensland, thanks to the Section 16 through 19 of the Fair Trading Act. And a lot of the sections inside the ACL, the Australian Consumer Law, actually apply regardless of whether the seller or the purchaser in a transaction is actually a consumer. Some parts only apply to consumer transactions, but some parts don't. They've got broader than that. And it's for you guys, as part and parcel with doing this subject and doing the assessment for it, you're going to have to go through that piece of legislation and determine these things. I'm going to try and help you out to some extent today by giving you something of a heads up on it. But before we move into the ACL, I'm just going to go through very, very briefly some of the particular parts that are the CCA. In other words, this is stuff which is done and managed usually by the ACCC. And it's basically the really big areas of market manipulation or misuse of power on a large scale. This isn't really to do with particular people acting badly for a particular transaction or series of transaction. This is about people manipulating their entire market. So if we think about the CCA, really that's an instrument that is there, gives powers to these regulatory bodies to look after entire markets and industries. And it basically gives them the ability to go through and regulate some of these areas. Anti-competitive behavior, in other words, things like price fixing. And you guys know what I mean by anti-competitive behavior and price fixing, where all of the players in a particular industry come together and they say, oh, look, we're the only ones doing this. How about we all bump our prices up? That is expressly outlaws. In fact, there was a famous quote that if parties do conspire to do this, it's a conspiracy against the public. And that the economists in us would know all about this idea that you don't want to have all of the players coming together and essentially forming a single player, an oligopoly. That's not what we want. And so that type of behavior is regulated and or prohibited, and the ACCC manage that. The same with misuse of market power, in other words, pushing your weight around. If you have or control, and if you think about this from business strategy, you guys have probably done business strategy. If you're a large player, airlines, good example. If you've got profitable routes, let's say Cairns Townsville. Cairns Townsville is a good one because for some reason that flight is really expensive and it's a really cheap plane that they put on it, and the staff look like they've been put out to pasture. And so, but they, by all means, they still charge you $300 or something like that to do it. So it's cheaper to fly to Brisbane. Why? Because there's competition on that line. There's no real competition between here and Cairns. So what in theory you could do if a new player comes in, new person comes in, brings their own little plane, you just lower your prices to compete for lower than them. Just lower your prices so that eventually they go broke, and then you rank your prices up again. That is a misuse of market power. Exclusive dealing and retail price maintenance is kind of the same thing. That's where you have trade ties in with particular products to sell particular brands of your own product. You insist on people not being able to sell other types of products. They can only sell yours. And again, it's really designed to protect the consumer in the broader sense, because they want people to be able to have choice. As part and parcel of that, and part of having choice means that in theory it makes things more competitive as well. So that's the CCA stuff. We don't really go too much into this for this subject. It's very much its own area, but it's really for your interest, particularly those that are studying economics. The main thing that we are interested in is the Australian Consumer Law and the various sections that come up there. We're going to start by looking the first of these, which is misleading and deceptive conduct. Now, interestingly, when the Trade Practices Act was put in place back in the mid-70s, Parliament didn't think this was going to come up that much. They thought that people would bring actions under Section 20, which is what your assignment's about, unconscionable conduct, rather than this one. But it turns out this one's huge upon huge, because the courts have expressed it in really, really wide terms. And so basically, it goes like this: a person. We're talking about elements. You have to have a person. Does a person? In fact, I can put this as a little thing. As a little. Oh! Always wanted to do this. Does a person include corporations? I better spell it right. Corp or rations. How about this? Let's put this to the quiz. What do you reckon? Dong, 7, 8. Yeah, that's pretty clear. I think we got a pretty clear winner there. Why? It's because Section 2, capital C of the Acts Interpretation Act says so. Parliament that's the Federal Acts Interpretation Act, even though this is Queensland law, the Federal Interpretations Act applies because that says whenever there is a reference to the word person, it means a natural person and a company, or any company, or a body corporate, or an incorporated society, or and so on and so on. Any form of body. Things can be incorporated under statutes. James Cook University is a person, an artificial person. All right, so a person must not in trade or commerce. All right, that's the second part. So you've got to have a person. It's got to be in trade or commerce and engage in conduct. So you've got three things we've got to talk about: person, trade and commerce, engaging in conduct that is misleading or deceptive, or is likely to mislead or deceive. That's a pretty minor point. But that's really the four things here. Oh, I can even do my little drawing. Oh, it's a good color. Green. Person, bloop. Trade and commerce, engage in conduct that is misleading or deceptive. That's really the main one. These are the main things we're going to look at here, and that is Section 18 of the Australian Consumer Law. So, what does that actually mean? Let us have a look. All right, so we've got a couple of rules on the next slide here. These are some of the elements. So that we have to look at each of these components. This comes from Duke Master, I think. But I think the example that I'll use is it's Taco Company and Taco Bell. Who's heard of Taco Bell? Yeah, I wish I heard of Taco Bell. Now, interestingly, they are actually operating here. You notice that Taco Bell is really recent in Australia. There's a reason for that. There's also a reason why Burger King is called Hungry Jack's, and they are both legal reasons. Because, and there's another reason, you guys, we all know about Starbucks, eh? All right. I think that you save that for other subjects. And so a bunch of the major American fast food type chain stores, they had a great deal of difficulty in Australia. So Taco Bell was one of those, and Taco Bell started in like the 60s or 70s in here, and they came back in the late 70s. They came and opened some stores in Sydney. All right, and there was a problem. The problem was there was already a guy who had a couple of stores, again, Mexican restaurant type things, that was called Taco Bell. They had been in Sydney for longer, and the Taco Bell International Company wanted to come in here, and so this went to court and opened some restaurants, and it went to court. All right, and both sides tried to sue each other. Who do you think won? I'm going to put the thing up there. I'm going to put the little thing here. Do we think, out of these two things, do we think that the international, who won? Question mark. The US company or the local stores? Go. Oh, it's a tricky one. This is just a guess for most years, isn't it? The fact that it's 50-50 means it's probably a guess. Well, I'll put you out of your misery. It was actually the local stores. And the reason for that required them to go through, or the judge in the federal court, to go through and examine the equivalent of Section 18 of the Australian Consumer Law and the Old Trade Practices Act to determine who's being misled here. Tala. Oh, hang on. Do I have to pull this off? Tala, you there? Question? Oh, I can't hear your microphone. Uh-oh. No, check your mic. Check your mic. I cannot hear, sadly. Oh, no, hang on. Oh, no. I'm so sorry. No, that's my fault. Now try again. Sorry about that. It's definitely my thing. I should be able to hear now.
Yeah,
Sorry about that.
So basically, the Taco Bell that is now open is a local chain?
No. What's happened? Taco Bell has only been operating, like in Australia. They tried in the 70s and they tried again just recently. They've cured all of this legal drama. Not sure how. I didn't investigate it. So the one in Townsville opened last year, I think. Like literally, it's been, what are we, 2020? Yeah, 2020 before Taco Bell arrived in Townsville. Because back in the 70s, they tried and they came here, and the local companies, and again, this went to the federal court, and they were trying to work out, well, in mapping these things out, what would an ordinary person think when they saw the name Taco Bell? You got to appreciate, in the 70s, in the eastern suburbs of Sydney, these stores had been running for 5 or 10 years. When the big multinational comes along, which store are people going to think that Taco Bell belongs to? Taco Bell? No, Taco Bell, the American multinational? Or Taco Bell, the local store called Taco Bell? And that's what they said. They said that, look, this big US company might be big in the US, and people that have traveled to the US might have seen it. Remember, this is a long time before the internet. But there's no mechanism for people in Australia to know anything about that. And as such, a person walking down the street seeing a store that says Taco Bell would go, oh, great. It's the same as that guy that I go to back in Eastern Sydney. But it wasn't. So they actually lost. They actually lost as part of that. I had the same moment. I had this terrible moment in my life walking through the back streets of Brisbane. Not Brisbane, Cairns. Is everybody here walk through Cairns? May have a franchising code. Yeah, you can do and have that, and that's what they were. But it doesn't matter because the franchisee would be and fall under the Section 18. Whether they sue the parent company or the local one really doesn't matter. Suing one or the other. So if you walk through the back streets of Cairns, there is a pub called the Cock and Bull. And I was so happy when I was walking just one day through Cairns, and I'm like, oh my goodness, it's the Cock and Bull pub, because I'm from New Zealand. And in 1995, a pub opened up not far from where I work called the Cock and Bull, and it was outrageously successful. They brewed their own beer, just like the brewery is down here. The Cock and Bull pub, yeah, that's the one, Siva, yeah. And so the one in New Zealand is just like the brewery, the big pub on the corner in Flinders Street is here, just like that. Very, very similar style. And so I was stoked. I love the brewery too. Got to go in there, and I walked in, and I'm like, what is this? What is all of this? It wasn't the Cock and Bull they had in New Zealand, all over New Zealand at all. It was completely different. I was very sad. If that had been not New Zealand, and that had been in Brisbane, or it had been, if the Cock and Bull pub had run in somewhere like South Australia or Victoria, the one in Cairns might have run foul of it, or vice versa. It's possible if the Cock and Bull, the one that I knew, opened up in Cairns, then it would run foul of this. They would think that those people would be misled as a result. Hina.
My question is, like, suppose we see sombrero and stuff like that.
Yep.
Can anyone just open a shop and give it that name? Because as far as I knew, the companies have some copyright that the name cannot be used.
Copyright? Yep, we do. We actually do an entire week on intellectual property to do with design.
Just a general question. So when the Taco Bell came to Australia, that copyright law was only in America?
Well, it's not copyright. First things first, I've got to disabuse you of that. It's not copyright. It's trademark rules, which are different again. And yes, you can go and register those things, but in order to register a trademark, you have to be operating. Both the same. What was it? Oh, I missed that one there. I don't want to have a read of that. Yeah. So trademarks require you to actually have Cold Stone and Creamstone. I don't know what that's. I'm not sure what that one is, but certainly the Wendy's. Oh, what products do you guys think of when you hear the word Wendy's? What product? Yeah. Yeah, that's good. That's perfect. Perfect answer, the pair of you. New Zealand actually has both. All right, they've managed to coexist for years and with both of them. You guys may or may not be, but there is an Australian company called Wendy's that sells ice cream, and there is an American company called Wendy's that sells hamburgers. In New Zealand, they've coexisted with no dramas, but Wendy's doesn't. The burger chain does not operate in Australia, at least not what I've seen. And that again possibly has something to do with it. Unfortunate with the name. As I said, the American companies have had a really hard time. It was companies which manufactures Winworth. Yeah, nice. Okay, so there's a couple of things we've got to talk about here. It's a bad burger. Oh, tell me about. Oh, not on the lecture recording. I had one of the worst experiences over summer. I'd been waiting to have Wendy's for like 20 years. Went back and it was the worst dining experience I've ever had in my life. It's terrible. Okay, so a couple of things we need to note here when we're talking about this. We've got to talk about the context of the conduct, the capability of leading things to error, the causation aspect, and no, that's about it. I won't worry about the last two here. So let's go through each of these things in turn. I'm going to go through these in turn. Right. First thing is context. Because even though we think when we learned about common law misrepresentation, misleading and deceptive conduct is far wider. We're just trying to work out, did people get confused? Did people get confused? That's really what it is. It's so broad, misleading and deceptive conduct. All right, it's a really broad thing that you can fall foul on. It's not a case of just making a misrepresentation from one person to another. No, it's not that at all. It's engaging in conduct. It can be broad-reaching conduct that is going to impact an audience of persons or a class of persons. Okay, and the first thing that we look at is who are the class of people likely to be affected. So again, going back to that example of the Taco Bell, people back in the late 70s, early 80s, when people are wandering through the streets, we'll say, of Darling Harbour, let's just say the Taco Bell Corporation, the big American one, have opened up a store right in the middle of Sydney, knowing that there's these two stores in eastern Sydney, Coogee Beach or wherever it was. All right, they've opened up some stores in central Sydney, like around Darling Harbour, where it's all very fancy. The first thing we look at is that who are the class of persons likely to be affected by the conduct? Who's the audience here? So here it's going to be probably people that would walk past the store, perhaps people that would operate in and around, say, Darling Harbour in this case, if that's where the store was. All right, and then once we've identified those people, and look, here we're not talking about people who live in Western Sydney. We're not talking about people who live in Brisbane, assuming they only opened that one store there. All right, then we assess and we look at what was the probable impact on them. And I love this phrase. We have to take into account the experienced as well as the inexperienced, and the gullible as well as the astute. In other words, when we're looking at this, all of the people in that class, people walking past this restaurant, okay, and they're walking into this store thinking it is the taco company from Eastern Sydney, and it turns out to be this big American taco company, all right, have they been misled as part of that? So we've got to think about the class of persons. Is everyone walking past that area? And what's the impact on them? They're probably going to walk into it thinking that it was the other guy's business or the other guy's store in that situation. Okay, and we only look at the ordinary and reasonable people. So in other words, if people, and again, this is a bit of a silly example because there's not really a lot of harm that comes from purchasing a taco from a restaurant. But if you thought about something else, for example, if you're a manufacturer of Louis Vuitton, Let's just say the same thing was slightly different, and you were a person in Eastern Sydney who had 2 handbag stores, and your name happened to be Louis Vuitton. Just imagine that. Again, going back 50 years, you happen to be called Louis Vuitton, and then the Louis Vuitton brand comes in and opens in Darling Harbour, and somebody walks into that one thinking it was yours, or vice versa, walks into either of those particular stores. Then we have to take things into account. You don't take into account people that don't take reasonably care of their own interests. Yeah, Tala.
All right. My question is, don't they take into account the investment in the brand name and marketing when they assess situations like this?
Yes.
Like if a Louis Vuitton person would be
Yeah.
great if you have 16 stores in Australia, but
Yeah.
LV as a brand globally spends a lot more money in saying than what this person would do. Like,
Yeah, it is. It's look. The more I've thought about it, I think it's possibly a poor example because the two don't actually sit comfortably together. It might be a better example if Louis Vuitton that does exist in Australia, and then there was a company that would come in and call themselves something kind of similar, or would have a similar sort of a logo, or would have stores that were set up in a similar sort of a way. I'm thinking maybe, yeah, I think your fashion's probably a good one. The only trouble was when me using brands and fashion brands is that I personally don't know them very well. Um, so when thinking of Louis Vuitton as they sell bags and all sorts of other things, I imagine as well, and whether they have a particular style of going through and doing these things. But if you opened up a shop in the and say in Stockland, the mall down here, and it was called Louis Vuitton, for example, and it had handbags, and you were selling them for $500 each. Maybe that's a better example. If you had gone through and done that, class of persons that you're likely to be affected, people walking past, we look at the experienced, the inexperienced, the gullible as well as the astute, but we only take into account ordinary people and exclude those that fail to look, people that put their head in the sand as part and parcel of this. So if I had gone, oh wow, there are these Louis Vuitton bags and they're only like $100 each, I'll go and buy 100 of them. That arguably that would fall foul of this particular part here. Really, it's tricky here because there's other areas of law that impact on this as well, tort of passing off and so on. But it is an area that, yep, replicas, yes, yeah, that's right. They are, yeah, that's absolutely misleading. Who was the class of person? Again, we'll use the test as well. So Ray-Ban, okay, good example here. If you've gone and imported you've got a huge number of knockoff, fake Ray-Ban, or you've got Ray-Ban and it's spelt slightly differently, or it's tricky when you're actually. Oh well, maybe it's not even that tricky. If you've got sunglasses that look almost identical to the real ones, are people likely to be affected? So who's the class of persons? Pretty much anybody that buys the sunglasses. What's the impact on them? They are likely to purchase at an inflated price cheap sunglasses and diminish the brand, as Tala or Hina had mentioned before, of the actual Ray-Ban people. But the court only takes into account ordinary and reasonable members. So in other words, people that are, that take some amount of reasonable care to look after their own interest as part and parcel of that. So that's just how this test is done. It's really broad in impact, and you can literally make an argument in any given situation where somebody's fibbed to you that here is the people that could have been infected, and this is the results in terms of what you do. And it's really up for you to just adduce that evidence to the court as part and parcel of it. Now, what you will find for things like Ray-Ban, in terms of the brand and the trademark that comes with that, is that there's easier law. There's easier ways to bring that under the relevant trademark breaches that we do in week 12 or so. And so that, yes, you can take an action under misleading and deceptive conduct, and you could run the two actions together. You would do that, though, if it was difficult, for whatever, you had some legal difficulties in establishing a trademark for a variety of reasons. That's the key thing there. Okay, that's the first. So context is important. You have to look at the audience. Then you've got to look at whether or not the particular conduct is capable of leading them into error. Right, it has to be capable of leading the intended audience into error. All right, and this again, go back to Target Company. It's not good enough if it merely causes some confusion or leaves the intended audience wondering. So confusion's not enough. You actually have to create some form of error as part of it. In other words, here, with your Shiva, with your sunglasses, now people are actually going and buying them. Yeah, yeah, yeah. That's right. So you got some things there. Now again, remember, misleading and deceptive conduct is only going to prohibit that aspect or that component of it, which is usually leading people into error. Okay, so if we think about that, the entire process of importing fake goods or knockoff goods from China or wherever like that is that entire process. It's only at the point in time where they start to go and distribute them that they're confusing people. Whereas under the trademark legislation, and you can do things at an earlier stage. And if there is copyright things as well, you can do that. You actually have the power to do things at an earlier stage as well. All right, because that's under a statutory framework. We won't talk about that until I think it's week 11, week 12. I don't know. It's all over the show this semester. Okay, so that just make note. It actually has to make people lead them into error, and by lead into error, usually they've gone to buy stuff. Because if they're going to buy stuff, and that's going to somehow diminish your brand in some way, that's the bit where you can go and bring the action. And remember also the consumer, the person that's gone to buy all of this stuff, can sue the person who's being misleading and deceptive. So you don't have to be the person who's bought the things. You can bring an action for Section 18 if you can prove these elements. Hey, here's the people. Hey, they've been confused. We would like a remedy, and that remedy can be an injunction stopping them from doing stuff, stopping them from carrying on trading. All right, there's a causation aspect as well. It's the particular person you're bringing the action against. Is only liable if found responsible. Yeah. There has to be this aspect of responsibility. It has to have causation as part of it. They have to be responsible for the error in some way. You do have to go through and prove that, and it's an objective test as well. I think I've mentioned that a little earlier. So that you go and you look. What would a reasonable person think in this situation? And also real and not remote chance, but I haven't talked about it in depth. And so that these three things, though, these are really the elements of it. It's causation, it's capable of leading a person to error, and you've got to consider things in context as well. That's really the key aspect of that. Okay. All right. Now, I don't think. I mean, you can as part of your assignment. I'm not sure whether or not I actually phrased the question for your assignment to be specifically talking about this section, Section 20 and Section 21 of the Australian Consumer Law. I think I did. It's certainly the bulk of your assessment task is this, and reading this particular section in Section 21, and then the list of things in Section 22. This is the bread and butter of that assessment piece, because it is a statutory interpretation task. You're going to have to go through, and you're going to have to work out how that statute works. And I recommend that you break this down into the series of elements that the plaintiff would need to prove. This one, a person must not, so you start with a person, trade and commerce, engage in conduct that is unconscionable. Oops, not drawing this very well. All right, this is the key word here, unconscionable. We've seen this word before. Where did we see it? 2 weeks ago when we were talking about vitiating factors. Blomley and Ryan is the case where that comes from. That idea of this list of people, the word unconscionable has a legal technical meaning, and it's in Australia it's to do with special disadvantage. If one party in again, in here, it's expressed in broad terms in trade and commerce. It doesn't have to be a contract. It's broader than that. All right, as long as it's done by a person and it's in trade and commerce. Person, trade and commerce, unconscionable conduct. Those three things you need to prove, and you can get a remedy under the Australian consumer law, which we'll talk about, I think, towards the end of this. We'll talk about what that actually means. Okay, now, where it uses the phrase within the meaning of the unwritten law from time to time, what the heck does that mean? Marie, what's your thoughts? Or Sukhpreet, or Michelle? It's the common law. It's exactly the common law. Perfect. So whoever sees that phrase, the unwritten law, that just means the common law rules. So we're just taking this definition of unconscionable from Blomley and Ryan. I'll put it on the thing there. Blomley, Ryan. Oops, no, not Lomley. Lol. Oh, they really? There you go. Lutica. Luxotica? Yeah, that. Cheers. Ray-Ban. All right. So that's what that word is. Now, the tricky thing is for you guys is that you have to use both of these statutes. So when you are doing your problem question, if you're only talking about one of these, you are doing your assignment wrong. There's your first hint. What you are going to have to do, though, is work this out. Trade and commerce in connection with the supply of goods or services to a person. Right. Yep.
Regarding the unconscionable conduct.
Yeah.
Unconscionable conduct. It's if you like if you made an agreement with someone that is stupid, he doesn't know what he's doing.
Yep.
That's not my fault.
It's about good conscience. Do you feel good doing it?
That is commerce anyway.
Ha!
Fair commerce does not exist because the assessment is related to this.
Yeah, it is. It is related. It's definitely related to this. So that you've got the idea is that look, we accept that private deal making between two abstract, reasonable persons, all right, that only happens in a minority of cases. This maybe a majority of cases. There are some situations where there's some form of defect as part of that. So we talk about this idea of there being unconscionable conduct, and the key phrase when we're looking at unconscionable conduct is to do with this idea of there being a special disadvantage. All right, and you have to, but it's more than that. You know, people have disadvantages all of the time. All right, but it has to be something else. It's got to be something else. It's got to be more than that. It's got to be more than a special disadvantage. The other side has to know about it and actively seek to exploit that. Again, that creates these circumstances that we consider unconscionable. Now, the key thing to note here, although I haven't put it on the slide, is that this first definition, person, trade and commerce, unconscionable. All right. The second definition also has those three elements. You might notice this: person, trade and commerce, unconscionable. All right. So essentially, in that part, it's the same. Is, however, the types of situations where this can come. In other words, the types of transactions where this comes up. Is this broader? Is section 21 broader or narrower? I'll put these as a quiz. Just bear with me. Broader, narrower. In terms of transactions. Let's go. So section 21, will it apply to more different types of transactions or fewer? If it's more transactions, it's broader. If it's fewer transactions, it's narrower. Okay, I had a little bit of a think about that. Okay, all right. And now I'll put it to you because this is in your assignment. Can both of these transactions apply to the sale of goods? In fact, do my quiz again. So the quizzes take a little bit of time to set up. It's actually kind of annoying. Can both apply to goods? Start. Yeah, both can apply to goods. All right, let's ask this again. Can both apply to land? Franceline. Is that how I pronounce it? I'm not sure. Question.
No, because one is unwritten. And the land is unwritten.
Well, no, it's on the screen. It's on the screen. Have another read of those. Francine, what was your question?
I don't think I just created it.
Oh, okay, sweet as. I do that too. No worries. Can both apply to land? All right. Let's go back again. This is an exercise in stat interpretation. All right. A person must not in trade and commerce in connection with the supply of goods or services. Does that include land? So, it's not supposed to be a trick question. The answer is no. This doesn't apply to land. It's only to do with goods or services. Well, the supply or acquisition of goods or services doesn't apply for contracts for land. Okay, that's a pretty big point. It's a pretty big point. Kuyen, yes. I probably mispronounced that terribly. Kuyen?
Can I ask a question?
Yeah.
Is that one regarding the assessment that applying when we're talking about the painting?
Yeah, it's all good. You're okay. Well, remember, there are two streams that you need to look at. One is for the sale of land. The other one is for the sale of the painting. All right, so there's two things that two potential actions you can bring here, and one of them you cannot bring. Oh yeah, cool. Yes. One of them you can't bring under Section 21 because it's to do with land. So Section 21 can't apply. But you will note, yes, Nathan.
So what happens for the land then? If they do a unconscionable transaction like this, took a special disadvantage over?
Well, you'll have to look through Section 22 because we're trying to work out in this situation whether it's unconscionable conduct or not. Whether it's unconscionable, that idea of there being a special disadvantage, which may or may not apply. But one thing that might apply is undue influence, right? But when you go and look at Section 22 of the ACL, it says for the purposes of Section 21, you can look at a host of other things. Okay, so basically this section, with my scribbles all over it, is narrower in the types of transactions. It only applies to goods and services. But the definition of the word unconscionable is actually broadened in Section 22. And one of the things in Section 22, subsection D, says is that definition includes undue influence. And in Section 22, subsection A, it says it includes, I think it's 1A. It says that it also includes inequality of bargaining power. Both of those things can be taken into account. Sorry, Nathan, I'll get to your question now. Well, does that help?
Yeah.
A little bit? It's a little clear as mud, this one here, eh? It just requires you to think about this because we've talked about these terms, that term unconscionable, all right? But we know That's a definition in the common law in Blomley and Ryan. This is a core part of your task, guys, because in that when you're trying to work out how this section works, well, you're going to have to say it's a person, they're in trade and commerce, unconscionable. Can they satisfy this being unconscionable at common law? Maybe, maybe not. And the defenses are going to be the same for both, for these things, for both actions to do with the lawyer going and getting independent third-party legal advice. So those defenses you're still going to have to talk about. But here we're looking at whether or not each of these two things can apply. And the one thing that you have certainly identified at this point is that for the contract for land, this one cannot apply because it only applies to goods and services, because that's what the section says.
Sorry, it's only under section 21, right? But still can apply in a different aspect.
Well, it can apply in section 20. You can make an argument in either of these, but not for land, not for this one, because it doesn't let you. It's only goods and services. So the types of transactions you can use is narrower for section 21, but the definition of unconscionable is wider, because they've said is, look, for the purposes of section 21, section 22 says you can take into account undue influence. And when you're reading the facts of this case, of that particular case, when you're reading it, it looks like it might actually, undue influence might apply. You might actually be better off making an argument for undue influence. But if you get off an undue influence, it's only going to impact a section 21 action, won't impact a section 20 action. You have to still use the rules for unconscionable conduct for that one. That is where we're going, as part and parcel of that. That's the key. Look, that's really the key thing of statutory interpretation that you have to be able to demonstrate as part of that. That's really the key thing you need for that assessment.
Did you ever clear it out if everyone needs it, otherwise just don't work?
Oh, no, I didn't quite catch that, Nathan. Sorry. Do you want to type it up in the chat?
No, could you ever explain it
Again? You want me to just go through and explain it again? Okay, sure. Okay, so when you are trying to seek a remedy, the person in the assignment, I can't remember their name, it might be Usher or something, I can't remember. They can try to seek a remedy under the Australian consumer law under section 20 and section 21. You can try to succeed on those things. But we've got two types of goods. You've got the paintings and you've got the house. So the first thing you need to know is that the paintings are goods, but the house is not goods. The house is land. It's real property. It's a completely different thing. So as such, you just can't use section 21 to do with a contract for the sale of land. All right? You can't use it. But for the purposes of section 21, for the paintings, it is going to be goods, so that's fine. And it's a supplies. It's expressed in very broad terms. All right? Again, you're going to have to make an argument whether or not it's in trade and commerce or not. You have to check that, whether or not it's done as part and parcel of the business or whether it's done privately. That's for you guys to analyze. And the key thing is, though, when you're looking at section 21, that you can also take the definition of unconscionable from the common law and look at extra things. You can look at inequality of bargaining power, and you can look at undue influence. So you can actually go through the rules for undue influence that we talked about in the same week and talk about this relationship of trust and confidence, whether or not a person's will has been overborne. In fact, you might even make an argument that the guy is a spiritual advisor. Because remember, we know that undue influence, a contract with a spiritual advisor is going to automatically be presumed to be undue influence. So if you manage to demonstrate to the court the guy is a spiritual advisor and this guy, other dude's a follower, if you succeed in doing that, undue influence is going to be presumed. And if undue influence is presumed, and undue influence can be taken into account for section 21, it's going to be unconscionable. you're just going to have to prove the other amounts. Is it person? Is it in trade and commerce? Was it a supply of goods? And the person one and the supply of good one is going to be really easy. Trade and commerce might require a little bit more argument, but that's really where you want to be doing, because that exercise in statutory interpretation is about going through the statute and using rules and definitions of words that you already know from earlier in this subject. You've gone and learned those particular terms. So you're going to have to go through and find Schedule 2 of the Competition Consumer Act, the Australian Consumer Law, read that section a few times, and read sections 20, 21, and 22 to try and work out how your client is going to get a remedy. And I'll explain what the remedies are a little later today. Does that make sense a little bit? Because that definition, and I've got some cases here in the next slide too. Blip. In fact, literally that definition of unconscionable in section 20 is widened in section 21, but the scope of transactions is more limited. In other words, that you can use it in fewer different types of transactions, but it's widened in section 21. In other words, you can include influence, but the types of transactions is more limited. In other words, it doesn't apply to things like land, for example, or contracts for insurance, or contracts for options, for example, things that are outside the scope of goods and services. All right, and the prohibition, just make note, prohibition against unconditional conduct, I didn't put this in here, but for the excuse, remember that if we've got this definition of unconscionable conduct, the person seeking to demonstrate that it's not unconscionable can follow the rules, and I think it's in Bridgewater and Leahy, that case there. In that case, that involved going to the solicitor. I think I'd mentioned this idea of going to the solicitor, but it was the same one, the same solicitor. So you might want to just follow that up in Bridgewater and Leahy. My computer is just having some dramas. Here. So now is actually a very appropriate time to take a break while my computer catches up. I'm not sure. Can any of you guys still hear me? Okay. I'm just going to take a break. We're going to take a break for 5, and I'll be back in 5 minutes' time. Get another drink.
Okay.
Thanks, fellas. Okie dokie. Oh, we're still recording. Now, I haven't put a lot of this in previous years, but I think they're pretty straightforward, I think. So I'm umming and ahhing about putting this into the exam. So there we go. I haven't read the exam yet. We're going to look at unfair terms. Now, just make note that unfair terms apply to what's called standard form contracts. Who here has ever tried negotiating the terms of a contract with Jetstar? Put your hands. Not one. It is not possible. You can't even find them. You cannot. If you do not like the exact terms that they put in, you have one option only, which is rapidly disappearing, which is fly Virgin. May or may not be a thing next year. And so what we've recognized is that, look, sometimes big, powerful parties, they push the envelope in terms of what they consider to be fair, because they get to dictate all of the terms that go into those things. And so Parliament's had to jump in and just say that, look, this, in some situations, it's just not going to work. These unfair terms. This isn't really going to work, and so we have to go through and so the courts have gone through to look at these and said that in this situation, okay, my slides are messed up here. How do I do this? In this situation, that Parliament just prohibits. There's these statutory rules that say that, look, if you're going to put terms that are in these standard form contracts that no one can ever negotiate, they have to be fair. You have to reflect the underlying power imbalance as part of that. And so what we've got, 3 cases here. The first one expressed in broad terms. Terms of standard form contracts, it's to do with this causing of detriment. All right, but most importantly, would a particular term cause detriment to a consumer? These things only apply to consumers, and without any significant corresponding benefit. All right, so that's really the key thing. Are they so one way that the other side doesn't get any benefit from it? And with Jetstar, of course, they can always point out that, well, you always get a cheap flight. And like the bag thing, for example. Oh, don't get me started on Jetstar and their bags. Who here has ever had to pay the last minute fee? Has anyone ever had that? No? Okay, you're all very good, sensible travelers. And look, the trouble is these things require often to be examined by the regulator. In the case of the ANZ banking group, the Picasso, sometimes it has to go all the way to the High Court. That case, famous case, went to the High Court to do with banking fees. And they said that, look, the banks, again, you guys have probably studied economics a bit more recently than me. People seem to be charged for their kids. Oh, wow. Oh, that's awful. How would you feel as the Jetstar person going through and doing that? And I had this argument last time I was there with they wanted to charge me for the bag. I'm just, oh, no, it's fine. I'll just put it on my person. So I literally just got my shirt, got my laptop, and just went, oh, here we go. Let's put it up my shirt. And they're like, oh, you can't do that. I'm like, sue me. Go on. Exclude me from this flight. I dare you. I mean, it's not like I teach contract law or anything like that. I don't know. And so there's these awful, just awful moments. Look, at the end of the day, you don't want to be negotiating with them. You want to be just usually avoiding their eyes. And if you think about it, you can be as heavy as you like getting on the plane. There's nothing there that says you can't get all your stuff, your excess baggage, and just stuff it all under your shirt before you go in. Or do like me at the check-in, where you go into the suburb of Garbutt. You guys are aware in airports, it's an offence to leave stuff anywhere on federal property, which airports are. So this Townsville's unusual, and so if you're ever about to be charged for excess luggage, you can literally walk into the suburb of Garbutt, put your stuff under a tree, which I did, then walk back in, check in, and then go back and pick your stuff up again and go through. But we never heard that. No one ever told. I never mentioned that. And so the part of this process is to really work out what's reasonable. What is a reasonable amount of a fee? And remember I talked about this idea of pre-estimated damages clauses or liquidated damages clauses, where you can estimate, look, if a person's going to breach a contract by this much, they're going to have to pay this much. And you have to just work out, is this amount reasonable or not? Because if it's not reasonable, it's not going to get up as a pre-estimated damage clause. The courts are just going to calculate it themselves. And so here they said a refund policy with a 15% administration fee, not reasonable. All right, not reasonable in that case for some medical company. Whereas a late payment fee on credit accounts weren't considered to be unfair if they were a genuine pre-estimate of damage. And so that in that situation, the banks had just picked a number from somewhere. And if they could prove through their own mechanism for calculating that extra harm, sure, they could go through and do that. But if they couldn't, they're not going to fly. And that the main time where it doesn't fly is where it's an automatic process, where you've gone and set up your software and you're still charging the same amount that you would for a manual late payment fee. That was not on. So anyway, that's unfair terms. It only applies to standard form contracts. So usually, again, from big players. All right, next one. Harassment and coercion. This is section 50. This is the last one we'll do with a bit of depth. I'll just go through the list of the other ones after this. Okay, again, we'll go through. These things are phrased and expressed as a series of elements: person, physical force, or undue harassment or coercion. Notice these magic words here, of course. So you've got to basically have this person. You've got to have one of those, and then it's got to be to do with supply or payment, of goods and services, or a sale of grant of land. So either of those applies. So you've got to pick this one, has to be satisfied. One of these has to be satisfied. And one of these has to be satisfied, either supply or payment of goods or sale or grant of land. So again, it's a little bit broader than section 21 because it can apply to land, but it doesn't apply to other sorts of contracts. It doesn't apply, for example, to contracts for insurance. Doesn't apply for contracts for buying and selling shares, not goods and services. It doesn't apply for again, granting of options on things or options to buy. It doesn't apply to things like guarantees. There's a huge number of things in our system of commerce where this doesn't apply to. All right. However, when we're trying to work out this thing, physical force is usually pretty straightforward. A person can't use physical force. You can't go to someone's house, threaten to break their kneecaps, or actually break their kneecaps if, in order to obtain or pay, remember this thing's expressed in broad terms, it's just got to be in connection with. Doesn't matter who the payer is, doesn't matter who the supplier is, doesn't matter where the things are. Don't use physical force in relations to these things. That's pretty straightforward. You could see why that would be a pretty straightforward thing to include in your legal system. All right. The other two are a little bit trickier: undue harassment or coercion. Okay, so we're going to talk about those and do a little bit more because the cases where this comes up is to do with those wonderful, upstanding members of society that we call debt collectors. Okay, because debt collectors are the types of people who call you up to demand money. All right, now, so these cases, I think they all involve debt collectors. There's one on the next page that doesn't, but the McCaskey and ACM group do. They're the main cases in this area of law. Justice French ended up becoming the Chief Justice 10 years later. He writes a lot. Robert French writes judgments that are many, 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 many words. So I'm not recommending looking for this case and reading it. Just get the summary. All right. So again, they start with the word harassment. This that McCaskey's case it's an interpretive one though. So one of the nice things is he has gone through and explained how the section works. When we're looking at doing stat interpretation, common law stuff, that really falls into two categories. You can have things which explain how a statutory rule works, and other things can define particular terms. All right, and those particular terms can be used in a variety of places in the statute. This one, McCaskey talks about, it does both. It defines this word harassment and explains how it fits and operates in regards to this section. And look, they said that, look, we use the ordinary definition, which is conduct tending to intimidate, embarrass, ridicule, shame, or otherwise distress a person. It's pretty broad. Okay, that's harassment. But undue harassment is more than that. Okay, because you are actually allowed, as part of things like debt collecting, to actually do a little bit of ridiculing, shame, intimidating, or embarrassing, or causing distress on a person. I imagine being called up and being told that I owe, I don't know, $13,000. I'm trying to think what debt I have. I don't really have much debt. Yeah, I do. I show $13,000. If I imagine that would be quite distressing. If I was called up. But if I actually owed $13,000, so it's a legitimate thing. The debt collector's calling up, say, "Hey, can you pay this?" And you say, "Yeah, sure." They can do that, and what they reckon is that they can probably do that once about every 3 days. They reckon that's most of the cases in terms of this comes out to about that. They can't call you every day. They can't call you multiple times in the day because that, and this, I love this phrase here, the frequency, nature, or content of the approach in communication is calculated to intimidate, demoralize, tire out, or exhaust. I love that phrase, tire out, exhaust. In other words, they're doing it so much, they're just trying to wear you down rather than convey the demand and the associated legitimate threat of proceedings. In other words, in situations where you actually owe them money and they can go to court, they can call you up every few days. Can you pay this money, please? Can you pay this money, please? They're allowed to do that. They actually are allowed to do it. That's legitimate to do that. But you've got to look at how much how often that happens. That's really the key thing. And so I said, most of the cases tend towards about once every 3 days. Every second day, you're starting to push it. Every day, no. Tala.
Off topic, but
Yeah.
it could be a humorous yet informative.
Ah, love it.
Have you seen the movie Girl in the Green Scarf?
I have not, sadly.
Okay, so the movie talks about this tax person that harasses this woman, and it's part of it. So if you ever see it, this would be a relevant example for that. I actually urge you to see it. It's quite interesting.
Okay.
Has
Anyone else seen it?
Girl in the Green Scarf?
I have not. I'm not going to Google it because my computer did something really bad when I tried Googling something just before. But we'll put it in the chat. I'll put it in the chat. All right. Google the woman. Was it woman or man? The girl. The girl? Oh, you got it there. Thanks, Tyler. Well, go and check that one out later. Just note, there's one important point to note about that, because it is a good point. Would the tax office fall foul of Section 50? There you go. I'll put that to the class. Oh, in fact, I love this. I'll bring up a little quiz. Oh,
No,
why?
because the tax office is the state. It's a government.
No. The government, the government agencies can still sue and be sued. No, that's the thing. That most statutory frameworks, when they set them up, say that they are not immune from prosecution. So would the ATO fall foul? I'll just put fall foul of Section 50. Oh, split. I love it when it's split. Oh, that's awesome. What are some reasons why or why not? Because you think, okay, look, they're a statutory body. They can sue and be sued. Not for sure. No, not for sure. It actually comes back to the definition. All of these things. Statutory interpretation is not about what we think. It's about what Parliament actually intended. In connection with the supply or possible supply or payment of goods or services, or the sale of grant, or the possible interest in sale of grant and interest in land, is collecting tax money, any of those. And the answer is no. It is not, just by definition, tax is not the supply or payment for goods or services. Tax is a different and distinct concept, and it's unrelated to land, obviously, as well. This section is broader. You notice that if you think about it, going back to this example of the TV, Enrico's TV. All right, so let's just say instead of me stealing it, I've come in and I've started to use physical force. Oi, Enrico's, sell me your TV, or I'll break your kneecaps. Can this section apply then?
No.
Why?
If you use physical force, no.
If I use physical force, or threaten to use, it actually includes threat, all right? I'm going to break your kneecaps, use physical force or undue harassment or coercion. Coercion, it'll fall under coercion as well, but threatening force or using coercion, which is the next slide, it probably would fall under that. And the reason for that is that unlike the early ones, misleading and deceptive conduct and unconscionable conduct, this doesn't have the requirement of trade and commerce. Why? We don't want people selling goods second hand to threaten each other. We want to be able to give people who are threatened or are suffering some sort of harassment or coercion, even in the second hand market, and people aren't in trade and commerce, we want to let them be able to use the Australian consumer law in order to be able to easily go to court and seek some sort of remedy as a result. I think that's how and where that comes about. That's the key thing. So this idea of Section 50 is expressed in terms of situations where it can come. It's actually much broader again, because it doesn't have a trade and commerce requirement. Either side doesn't have to be a business. So make note of that one. Again, that's the sort of thing as a stat interpretation question. Look, for you guys, this is the sort of stuff that might probably likely to come up in your final exam more than the stuff in the next for the next few assessments. And the reason for that is that statutory interpretation is absolutely pivotal. It's completely key to this task, particularly those who come from civil law countries. Reading the statute, and this is a lot shorter than what you're used to. It's only one page. Okay, so we'll so this third bit though, this idea of coercion. So we've got physical force is pretty straightforward. Undue harassment is that it can't be repeated or again and again and again and again and again. But coercion as a concept is stronger. This is where you are you're curtailing a particular entity's ability or choice or freedom to act. All right, and the example here, like I really have to have some examples here. It's the ACCC and Maritime Union involved a boat, and the boat was in port somewhere, and the union of the people that did the load of the boat, doing the loading boat, said that we won't let the boat out of the harbour unless you contribute to our social fund. Right? Not that we want the money directly, we're not threatening that. We won't let the money out of the port as a result, because I can't remember, there was a reason for it. The union felt aggrieved by something, the changing conditions or something similar. So they said, look, as a compromise, we'll just say, in our great magnanimous self, you can, we'll let your boat out, but you have to donate some money to our social fund, not to us individually, but our social club. And there they said, no, you are curtailing that entity's ability to leave the harbour, and that can fall under this umbrella term of coercion. So it's much stronger than harassment. Unfair, yeah, that's right. It's not merely unfair. It has to put people in a situation where they have no choice to do something. All right, and it's this idea of that we think about of this illegitimacy as part of this process, similar to common law duress or to undue influence. This sort of illegitimate pressure. It has to be really, really unfair. So much so that they've got no other choice, again, to do those other things, to supply or pay for goods and services. Am I echoing? No, good. No, it's just somebody's loop. make them stop me. Well, that's right. That's right. Well, that's funnily you should say that when we're talking about duress, that is exactly what the courts used to think. The courts used to think. I'll just paraphrase the question, which is Enrico's, even though he's ha 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 like tongue in cheek. No, actually, that's generally what the courts used to do. They used to say that, look, in that situation, look, if you're threatened to just sell the goods or do the other thing, all you do is just go through with the contract, and then you sue them for the tort of battery or the tort of assault or some other area of law. And the court said, no, that's not how this is going to work. Sometimes that the goods themselves, we need to have a separate action for this, where people threaten or use this illegitimate pressure to overwhelm people's wills and give them no other choice. It's not fair. And so the law is developed to take those situations into account. But just note, threatening to sue somebody is not coercion. It's just not. That's ordinary business practice. Demands calculated to intimidate or threaten a debtor and not merely remind them of their obligation. This is similar to harassment as well. That idea that how you're going about telling a particular person who owes you money to do things matters. Calling them up at 3 a.m, calling them up and threatening to tell all of their friends and family about it, that goes above and beyond merely reminding them that they have to pay this particular debt. Okay, that's what we call, when we think about coercion, it's putting people in a situation they've got no other real choice in that situation. Okay, and again, it's going beyond the legitimate purpose of drawing attention to the existence of the obligation and the consequences. That's how it can come up in that situation. All right. Oh, close to the end. Ish. I'll take that back. We're coming to the end of this. These things don't come up much. Offering prizes without ever actually intending to supply them. Some of these things are hard to prove. Bait advertising. That's, for example, where I see an ad for a computer at Harvey Norman. It says computers for this model are selling for $1,000 at Harvey Norman. Oh, great. When I arrive at Harvey Norman, they only had 2 of those computers, and they sold out at 8:02 or whenever the store opened, and I've got there at 10 o'clock. And so I've got out of bed, I've gone and driven all the way to Garbutt to go to their store. That's called bait advertising. You can't do that. That's an unfair practice. And again, you can seek remedy under this. Rolling accepting payment. That's where you know the situation that you aren't going to be entitled to payment for something. Unsolicited supplies. That is where you drop things off at people's house. Used to be a thing. Thankfully, they got rid of it. You drop things off at people's house and then say, if we're going to come back and collect this, if you don't want it, just leave it in your letterbox and we'll come and collect it. But if you take it and bring it inside and use it, then we'll send you an invoice for $50. No, can't do that. It was unsolicited. Pyramid schemes. You guys know what a pyramid scheme is? Going to use my blank whiteboard. Pyramid scheme is where you. Yeah. Okay. Good. Business students. It's great. I've lost my file. Cool. That's good.
Invented in 1902 by an Italian called Charles Ponzi in New York that fraud all the other Italian immigrants for 12 million.
Oh, nice. Yeah, it's something I do have to say that it's very the migrant communities have a hard time, and I'm just going to tell us that my friend here, by the way, who when you move to a country, there's a tendency for people to deal with people, particularly where your language is different, to clustering. You spend time going through and talking about it, and it's hard to assimilate. It's also very hard in terms of your visa requirements. So I said, my friend, she's been in Australia since 2008. She just got her PR literally today. It's taken like 12 years. And these things, it takes a long time to go through and do those things and jump through those hoops. And so you do have that situation where, again, special disadvantage is part and parcel of that. But it's really hard because migrants often don't have the ability to access the law in the same way as others. And referral sale. Oh, Amway. Remember Amway? See, the thing is with this is that Amway and friends, it's funny, they're quite similar in terms of where they sit in the ACL. This, people that would sell all of those, the herb stuff, the natural herb stuff and the makeup, certain types of makeup. These things, in many ways, are often similar to this. and that you don't usually make a lot of money selling the product. You make your money by getting others to sell the product, or even better, getting others to get others to sell the product. You can see where I'm going here, and why that these two things are actually kind of tightly related to each other. Multi-marketing schemes, multi-level marketing schemes, they're also called as well. And they are unfair and they are unlawful, and you can seek compensation or other things under the Australian consumer law as well as part and parcel of that. Okay, I don't go into those into too much depth. What I am going to go into is stuff that, again, is more likely to come up both in your life and possibly your assessment, which is the consumer guarantees component of the ACL. Okay, so that basically there's a bunch of terms, guarantees they're called, that are implied through the statute into contracts where one or both parties are consumers. And very importantly, Section 64 says those guarantees you cannot remove. If one party is a consumer as defined in this Act, you can't contract out of that. You can't just say, oh, as part of this contract, we don't guarantee these goods are fit for purpose. We don't guarantee we have title. We don't guarantee these goods are safe. No, can't do it. Can't do it at all. That's an important thing to note here. So sections 51 through 63, I'm going to go through some of them now. And you'll notice also here, they have a corollary, some of them, in the Cellar Codes Act. They look similar. They actually quite look similar. So that when you sell something, you must guarantee that you own the thing you sell them. You have this guarantee as to title. You have a guarantee as to what I call undisturbed possession. In other words, the person can get it and have the thing and not have others come and pick it up and do things. You guarantee that there aren't undisclosed securities. In other words, money isn't owed on that, and this thing isn't being used as collateral for any other contractual obligation. In other words, you're not going to have the debt collectors arriving to pick up your motorbike that you're selling. You guarantee that goods are of an acceptable quality, and this is different, and it's a higher standard than merchantable quality. When we think about the Cellar Codes Act, it has in section 17, it says goods have to be merchantable. That's for merchants, when people are in the trade and commerce come together and do things. Here, though, acceptable quality is higher. Goods have to be safe, they have to be durable, you have to guarantee the ability of section 58 to get spare parts. They have this idea of acceptable quality is much, much, much higher than that. It's got to be fit for all reasonable purposes as well. Not just things you've disclosed. It's got to be fit for all reasonable purposes, as well as things that people have disclosed as part and parcel of that. Oh, my thing's moving. Not too sure how that moved, but that's fine. Okay, and so that I love this. Just had a drama with the with my bed. My bed fell to bits, and you have to. It's going to be fun going back and taking it back to the warranty people. But at the end of the day, that's consumer goods. I'm a consumer, which we'll get to in the next slide. It has to be fit for all purposes as part and parcel of that. It also, it has to comply with the description if there's a description of the goods, and it has to comply with a sample if you supply a sample as part of it. So all of these particular terms you can't remove if those goods or services are being supplied to a consumer. I'll bring this up now. Definition of consumer is here. I've chopped out some bits. So we see the 3 dots throughout this. You'll see little bits and pieces. You'll see little 3 dots here and there. That means I've just removed some bits for the purposes of you guys. This makes it a little easier to read. If you don't think this is easy to read, yeah, this is what you want to be using because it's the actual section itself is much, much longer. It's got other fluff in there, gift cards and trailers and stuff. Don't worry about that. The key thing to note here, all right, when you're reading this as part of your interpretation, which, and again, this is the sort of thing that's bread and butter for exam questions. A person, well, we know that definition of the word person, that's fine, is taken to take particular goods, so they've got one for goods and one for services, just doing goods first. As a consumer, you are going to be considered if the amount paid is less than $40,000 or the goods are of a kind ordinarily for personal, domestic, or household use or consumption. Okay? So, what does that include? A car. You can buy a $5,000 BMW. It's going to be fine. Okay, that's going to you're still going to get the guarantees in the Australian consumer law. If you bought a $550,000 machine of some sort from an engineering firm, not going to apply. If you buy a $35,000 machine from an engineering firm, all right, and you're just using it, a Ferrari 55k, there you go, 550k, no dramas. Is it for personal, domestic, or household use? You can make an argument if you're racing it, probably not. And the reason for that is that subsection 1, so this will not apply if you are purchasing them for the resupply or using them in production or manufacture, or using them in repairing or treating goods and fixtures to land. All right, so break that down. And this kind of makes sense. If you are a company, right, a big company, and you have a branch, we'll say in Hermit Park for your multi-meal, let's say your Taco Bell, and your Australian head office happens to be in Hermit Park in Townsville, and you send your Office Junior across to Officeworks to buy some stationery. All right, just buy some stationery for the office. Should the Australian consumer law apply to those goods in terms of the guarantees? And look, what we've said, thrashing this out through Parliament and backwards and forwards, is that basically yes. It's much easier to just have the same amount of guarantees for people who are using things like that ordinarily. All right, if you're not spending much money, or you're using things for your household, you're going to be considered to be a consumer. But if you are taking those goods and selling them, or you're using them, either for production, in other words, part of some sort of business, or you're putting them and affixing them to land. And in 3 weeks' time, we'll talk about the mechanics of doing that and the legal hurdles and challenges with this. In that situation, you are not going to be considered to be a consumer in that situation. So if you're buying stuff, so that's really interesting actually. So if you go to Bunnings, all right, and you take something, you buy a sparkle from Bunnings for $350, and you take that and you put it and affix it to land. Oh no, it's the trade and commerce. I was thinking, no, that does still apply. It's got to have this one here as well, and trade and commerce as well. So if I'm doing it at my own house, no dramas. If I'm doing that in my workplace, then there's going to be dramas as part of that. I was just trying to think. I'm sure that sparkle example doesn't work. That's why I missed. Sorry guys, I missed that particular word there, which is trade and commerce. Really important. So this resupply doesn't matter if you're in trade and commerce. If my child, which he does do, goes to Coles, buys a whole bunch of Pepsi Max when it's on special, goes and sells it for $2 a can, can he use the Australian consumer law? No. Because the person has acquired goods for the purpose of resupply. So even though he's only 9, he will not be able to use the Australian consumer law. And similarly, if he took the stuff, used it in trade and commerce for his business to produce or manufacture things, or to do things, affix it to land, it's not going to apply. Does that make sense? That's worth getting your head around, that particular section. Again, that sounds like a pretty good thing to assess, I think, as well. It's a statutory framework. It's simple. It's relevant. It's super relevant in terms of the guarantees that you get. And so you can make business decisions based on it. Seems like an appropriate thing to examine on. And I'm not assessing it as part of your assignment piece. So I'd genuinely say that's a likely one. And for this particular exam, your 30% exam, it's only smaller. So you're going to have a series of smaller questions that are going to require analysis. This is the sort of thing you want to be taking note to. So just know, the one for services works similarly. It's if the amount doesn't exceed $40,000 and the services are of a kind ordinarily acquired for personal, domestic, or household use. The same thing applies there. All right. So you can only get consumer guarantees if you are a consumer. Remedies. So I've done 2 slides here. One is for the remedies you get under the sections I talked about earlier in the ACL. Misleading and deceptive conduct, unconscionable conduct, unfair terms, and harassment and coercion. And all of those other ones, pyramid schemes and referrals and all that sort of stuff. The main thing you can get under Section 236 is damages, $1 reward. Here, have some money. But one thing that the court can do under the Australian consumer law that they can't do under the common law rules are all of these ancillary orders here. All right, all of these things here. Just determining to make the contract void, changing it. Remember that varying the contract, this is something that can actually only be done in equity. Injunctions can only be done in equity. You can't, the courts of common law can't do it. So all of the equitable rules apply as part of that. You can order the repair or supply parts. Now, usually the courts can't order people to actually go and perform things. That's specific ones. That's akin to slavery. But they can do it to make them repair or resupply parts as part of it. They can direct refunds or return of property, obviously refuse to enforce the contract and order them to supply services to actually go through and do that. Usually, though, the courts are going to follow the rules of equity. They're not going to make people turn up unless it's really expedient. Usually, this is going to be the main one here. They're going to get dollars. That's usually the main remedy here. And just make note that by default, unlike, this kind of makes sense, when we talked about the principle in Robinson and Harmon, the idea that damages in contract law is designed to put you where you would have been, not back to where you were. So the expectation loss as opposed to reliance loss. Just make note that in the ACL, it's actually reliance loss. That's the basis of things. And the reason for that is that it's twofold. Generally, these things are to apply to put people who aren't trying to use the Australian consumer law or things in order to sue for breach of contract as such. Because if you can sue for breach of contract of common law, you're a sufficiently powerful party, you go through and use the common law rules. Usually it's people who are in a weaker position, and usually we're not going through and calculating what expectation loss is in that situation. The courts can do it, but generally they go through in terms of doing these sorts of compensation orders and working out what damages are. Usually they go in reliance loss. They're really designed to put people back to where they were. So the key thing to note here, if you do get this in an exam question, is be thoughtful about what the parties want. And just make sure you note that a particular person can ask the court for one or more of these particular remedies as part of their action. Okay, final slide. Consumer guarantees. These fall into 2 categories. If you've there's a TV show called it's called The Checkout. I don't know if it's still on. It used to be on iView on demand. In fact, I'm not going to Google it because if you do go through, they talk about how these particular rules work, and they talked about major failures, major failure. And as you could imagine, a major failure where there's something substantially wrong with particular goods or services, you can reject those goods, return them, get a refund. That's pretty much. And look, it's a no-nonsense series of remedies here that you can always go through and get. Whereas a non-major failure, a small one, requires them to remedy, and if they don't do so, then you can go through and terminate, then you can go through and do it. So the example that I have is actually from my own life, which is to do with, in fact, I've got 2 examples. I've got 3 examples I can talk about. So the first one, in regards to this, was when I had a business with my friend. This is in the year 2000. I was 22, my friend was 18, and we'd sold a computer that we built to a 20-year-old. So this is quite a fascinating time. We went to the equivalent of QCAT, and the member who ran it was very, very, very good. And I'll never forget this. In fact, if anything, it was one of those things that led me to want to do law many years later. And he went through and explained the equivalent part of this consumer guarantees. This was in New Zealand, so it was under the New Zealand Fair Trading Act at the time. But he explained that the particular failing that it had in that first instance was a non-major failure. So the guy couldn't terminate the contract. We had to remedy it, and we couldn't go through. It couldn't go through and just return the goods, which would have caused a grave injustice on us at the time. And so we did that as part and parcel of it. And he then determined later on, like 6 months, 12 months later, the hard drive broke in it. There he said that, look, this is a major failure in that case. And he required, there was something quirky in that we hadn't received the deposit. So the guy hadn't actually paid the deposit as part of this particular computer, $700 or whatever it was. There they said, we have to remedy this defect and we don't get the deposit. So the guy refused to pay it. Look, I think in hindsight, the guy was kludging it a little bit. Strictly speaking, we would get to keep the deposit, which hadn't been paid, and have to refund the computer as part of it. So it was a little bit strange because the guy hadn't actually paid the deposit at that particular point in time, but had paid the bulk of the thing. So it was a little bit of a kludge, but essentially the guy made the distinction between a minor failure, one that can be remedied, and a major failure which can't. And so the courts will go through and determine that thing. And you guys need to know and think about that as parcel of it. I think another example I can use from this lecture, I think is hilarious, but you guys might not. Do you want some more examples of consumer law coming up? Because it's really to do with stat interpretation as part of it. Go for it. Okay, so I wanted to be a JP. JP is a notary public, or a justice of the peace, it's called in Australia, in Queensland. All right, I wanted to be a JP. So I went to the website for the JPs, all right, and they said that in order to be a justice of the peace, you had to fulfill these 4 things. And you can go and look for it now if you guys are interested in this. Right, you have to be an Australian citizen. You have to be on the electoral roll. You have to have done a course, a JP's course, so like a 2 or 3 day course. And you have to be of a fit and proper character, which usually means signed off by the local MP. Right, so you've got to do those 4 things. Okay? And I went to the Department of Justice and Attorney General's department, and it also had those 4 things. All right? So that was fine. So I went and paid $360 to the Queensland Justices Association to do this course. This course was $360 because by that stage I was on the electoral roll, I was an Australian citizen, I presume I'm fit and proper because they let me be a solicitor. Okay, so that was fine. And at the end of the first day, I happened to be in the law school, and I was talking to Stephen Graw, the guy who wrote the textbook. And he said, you don't need to do that course. You're a solicitor. And I'm looking at that going, what? Oh, I'm like laughing. Maybe when you became a JP in the 70s, Steve, you definitely have to do the course because it says so on their website and on the Department of Attorney General site and in the course materials that you do on the very first task that you do as part of the course. All right? Anyway, I went and checked the Act. It turns out Steve was right. I was wrong. Never, ever try to, ever try and argue with Steve at any point of law. It just ends really awkward. And turns out, as an Australian lawyer, I did not need to do the course. So what did Simon do? He asked for his money back. And what are the what do they call the Queensland Justice Association who ran this course? What did they say? What do you think they said? No, yeah, that's right. They told me to, no uncertain terms, to bog off. All right, and the reasoning they had was really bad because their reasoning was, well, we don't guarantee you that just doing the course is enough to make you a JP. I'm like, no, you misinterpreted that. It's not fit for purpose. All right, it's not fit for purpose. And so that, in other words, has to be fit for all reasonable purposes. All right, so the consumer guarantee. All right, and what's the problem though with trying to get them under misleading and deceptive conduct? What's the problem with that?
It's like if you're going to steal in a stealer home, you know what I mean?
No, this is statutory. It's on the screen. Literally, it's on the screen. So I want to try and seek my $360 from the Queensland Justice Association misleading me. All right, what's the problem? Why can't I use this section here?
Because it does not apply to courts or judge or things like that.
Yeah, although it's you're on the right track. It's up here. It's not in trade and commerce. It's what the statute says. The Queensland Justice Association is an independent association. Normally, you could sue those. So, for example, you could sue the Cowboys Leagues Club, for example. You could probably sue. They'd probably count as being in trade and commerce, but not the Queensland Justice Association. Not going to work. So I can't use this. I could still take an action in what? What's the action that I could take, though, in common law? Any thoughts? What could I do to seek my $360 back, to try and have this contract undone? It's common law misrepresentation. They've induced me. Yeah, well, it's not mistake because I'm mistaken. It's a unilateral mistake. I'm mistaken. They're not mistaken. Or maybe they are mistaken, but but either which way, I'm going to have a hard time going through. Actually, I didn't really sort of think of mistake as part and parcel of it, but it's more that the representation that's been made on the website itself, which doesn't form part of the agreement, doesn't form part of the contract, but it induced me, was material in inducing me into the contract. It was false, so I could bring an action in common law misrepresentation, but I'd have to go to court. You can't go to QCAT. If you want to take an action against a trader, a small action for less than $25,000, you can go to QCAT. You can't for a common law action. You've got to go to the magistrate's court. And I wasn't willing to go to magistrate's court, paying $300 application fee for $360 back from the Queensland Justice Association. And I'd feel a little mean doing that because it's a not-for-profit. So I let that one go. Anyway, I'll probably leave it at that there, guys. So I know it sounds like a little bit of a silly tale. But these things come up. And you'll find that often your barristers, we had a barrister come to a guest lecture a couple of weeks ago, and he brought a series of examples. When I'm looking through, I'm immediately knowing that they're going to be his because they were for like $500. No one's ever going to pay a barrister to try and get $500 back. That's just not how this works. All right, so I'm going to leave that there. If you guys have any questions, ping me on there. Otherwise, I'm going to stop the stream. I'm going to stop the Collaborate recording, and everyone gets to go home. Hang on. Oh, look, everyone's home. Magic. Let's
Just one question.
yeah, go.
Regarding the lesson, it's regarding the assessment one.
Joshua, the test. Yep.
The test. There was one question. I think was there was the double answer.
No, double answer. Yeah, I saw that one there. It didn't change it because it wasn't the right answer anyway. I mean, it was just duplicated. It's my mistake as part of that. Yeah, I thought about it with the test. I was umming and ahhing about letting everyone reset it, but I don't know. What are you guys' thoughts on that?
I made one mistake from that one because I was sure the right answer was not there.
Ooh. Do a screenshot. Do a screenshot and send it to me. Or if you can remember it, type it out and I'll go and have a look. Because those things, look, it's possible some of them are wrong. I mean, probably not because I've been using them for a while, but often it's the way they're phrased can be a little bit awkward. And I've noticed that sometimes I've had to go back and read a few things a few times and then go back and look through the answers and go, oh, okay, I can see where the reasoning is there. The language is a little fluid. And look, it can be pretty hard for these things there. If you, again, if the class overwhelmingly wants another go at the test, I'm happy to go through and open the test again, but that's really up to you guys. I haven't heard nobody's jumping up and telling me to do it. It's okay. That's one's enough. It seems fair. It seems fine. All right, team. I'm going to leave it there. I hope you enjoy the weekend, and we'll or the weekend, the week. Remember, we've got a whole week, so you're not going to see me next week. It's going to be the week after. So flick through any emails if you have questions. Remember, a complete draft. This is the key thing. If we can have one, we go to the test. I think I'd have to put it to the vote. I'd actually have to talk to my boss tomorrow to see whether we can do that. If I do, I'll send an announcement if I'm allowed to. I probably not, but we'll see how we go. And it's really, to be honest, it's whether or not the vast majority of people want to go through and do it. So I'll tell you what, if I receive, how many in this class? 30. If I received 15 emails saying, please can we redo the test? If you send me an email to my simon.walker@jcu saying, yes, I'd like to redo the test, then I'll go and talk to my boss. But it's really up to you guys. I need 15 emails before I'll move on that. So I'll leave you guys in the chat to talk about that one. I'll jump out of the room. But I'm going to turn the recording off. And remember, it's 2 weeks. We've got 2 weeks between now and the next one. Okay, so I'm going to jump out of the room. You guys can do those things together. If you want to get 15 people to do it in the chat and just send me one email, that's even easier. If you get 15 people to accept for that in the chest, write a sentence or two. But I'm jumping out of it now because I can't be involved. Please don't send email. Okay, I'll leave you guys be. Thanks, team, and see how we go. Don't send an email. See ya.